Hello, my name is Michael Massman, and I'm an attorney with Neighborhood Legal Services of Los Angeles County. This presentation is about credit card debt and what to expect if you're being sued for credit card debt. The presentation is meant as information only. If you need legal advice, you should discuss the specifics of your case with an attorney. With that in mind, let's talk generally about what it means to be sued for credit card debt. First of all, it doesn't mean that you will go to jail. It does, however, mean that you could be forced to pay money. It's important to keep in mind that you have options, and some of those options may involve going to court, some may not. So we're going to talk a little bit about those options, and one principle to keep in mind as we consider those is the burden of proof. And that simply means that it's the credit card company's job to prove that you owe the debt. It's not your job to disprove that. Practically speaking, what that means is that the credit card company or debt buyer has to put forth an argument, and you as the defendant can sit back, since they have the burden of proof, and attempt to poke holes in their argument. Some more on that in some of our other presentations. So before we get a little more into this, let's define some very specific terms. So plaintiff, that's the person or company that begins the lawsuit. And the defendant is the person being sued. Summons and complaint are official court documents that have to be delivered or served upon the defendant. The summons tells the defendant that there's a court case and the court where it's occurring and to come to court. The complaint contains the specifics of the issue the plaintiff has with the defendant and what the plaintiff wants the court to do. In this case, that's generally enter a judgment for a certain amount of money. An answer is an official document that the defendant files with the court and serves on the plaintiff in response to the summons and complaint, and it asserts legal defenses, that is, legal reasons why the defendant may not owe the money. Finally, a judgment is the final determination that a judge will make if the case does not settle before going to trial. So to review a little bit, the summons and complaint starts the lawsuit. That's going to be served on the defendant. After the defendant receives the summons and complaint, that defendant has the option of answering the complaint. If the defendant files an answer, the court will set a trial date. That trial date is generally about 1 year from when the court case was begun. And if the defendant loses at trial, the plaintiff can then get a judgment and can begin collection actions. On the other hand, if the defendant wins, of course, the plaintiff cannot do that. So as I said, there are options. You see 4 of them here. Answer the complaint, negotiate a settlement, do nothing, or declare bankruptcy. We're going to talk about each of these in a little bit more detail in the coming slides. So first option, answering the complaint. This means filing and serving an answer. You file it with the court, you serve it on the other side. In California, there are court forms that you can use to complete this answer. The court forms allow you to make legal arguments about why you do not owe the money. Importantly, an answer is not a time to explain why you can't afford to pay. While this may be sympathetic in any individual case due to illness, loss of job, these are all sympathetic situations, the judge can only make a determination based on a legal defense. So a legal defense is something like, I never had this credit card, or they waited too long to sue me. They have a limited amount of time to sue you if you don't pay the credit card bills. And then, again, after you file the answer, the court will set a trial date. And again, that's usually about 1 year from when the court case was filed, at least in Los Angeles County. Some things to consider before answering. What happens if I lose? It's always a good idea to consider the sort of worst case scenario. If I lose, can I protect my income? What are legal defenses, and do I have any? That's basically, do I have a chance in this lawsuit of winning it or getting it dismissed? Can I settle without going to court, and does that make sense? And finally, if you are going to represent yourself in court, you need to ask yourself how hard this is going to be, how much time it's going to consume, stress involved, and whether or not you feel you have the capacity to do that on your own. There's a little bit more on answering and what that involves in our next presentation and some other presentations. So I encourage everyone to look at more material on our website. Second option is doing nothing. If you do nothing, you will certainly lose the lawsuit. They will enter a judgment against you. It's called a default judgment. That's the type of judgment that a plaintiff will get if the defendant does not respond. The advantages of this are that the case ends more quickly. You don't have to go to court. You don't have to fight. You don't have to deal with the stress of trying to defend yourself. And you don't risk paying attorney's fees, which can happen. Sometimes if you lose a lawsuit, you can be obligated to pay the other side's attorney's fees. So sometimes fighting the lawsuit, if you don't have a legal defense, can end up just sort of making it worse. And not answering may make sense. The one case where it often makes sense is if an individual just doesn't have anything that the other side can get, even with a judgment. So that's something to consider. Third option is negotiating a settlement. If you're being sued, that involves reaching out to the lawyers for the credit card company about a payment plan. There are limited resources available to help with negotiation. If you want more information on that, you're welcome to reach out to Neighborhood Legal Services. Our information is available at the end of this presentation. If done properly, the settlement will end the lawsuit. And it's also important to remember that you can negotiate at any time. Sometimes it might not make sense to negotiate right away. You can negotiate before you're being sued. You can negotiate while the suit is ongoing, right up to the right before trial. You can negotiate even after trial and even after they've begun collection actions. Theoretically, a negotiation's always an option. Option 4 is bankruptcy. You see here we've put a picture of Abraham Lincoln, known as Honest Abe, despite his other shortcomings. He's here to illustrate 2 points. First of all, he's one of 7 presidents in the United States that has filed bankruptcy. So he shows you that even very successful people occasionally need the fresh start that bankruptcy can provide. Also, he's meant to highlight that only debts incurred honestly are available for discharge, discharge being the official term for getting rid of a debt in a bankruptcy. So debts incurred by fraud, for example, are not eligible to be discharged, and there are indeed a number of debts aside from that are not eligible for discharge. Bankruptcy also runs some risks of losing valuable assets, potentially even your home. So it's important to educate yourself and think a lot about bankruptcy before just jumping in and filing, as you can put your assets at risk. Free legal help may be available. I encourage you to reach out to us. You see here a link to our website. We have self-help services available for both bankruptcy and responding to debt collection actions. If you go to our website, you will see a self-help questionnaire there. If you fill that out, one of our paralegals or our intake screener will get back to you about the next steps. Thank you very much for your time and attention. If you would like to learn more, please see our next presentation to answer or not to answer, as well as other material on our website. Again, thank you for your time and attention.